Okay, good morning. Going to call the Legislative Committee on Administrative Rules to order. First item on the agenda is to convene and review and approve the minutes of November 4th, 2021. And before we do that, we'd ask that the members of LCAR introduce themselves, starting with the Northeast Kingdom.
Thank you, Mr. Chair. Representative Mark Higley from Lowell, and I represent Lowell J. Westfield Terrain E. I am Joe Benning. I am a state senator from the Caledonia District, which is all of Caledonia County and 6 northeastern towns in Orange County. I chair Senate institutions and serve on the Senate Judiciary.
My name is Andrew Dexter Cooper, and I'm in the Office of Legislative Counsel, and I hope this wonderful committee.
Representative Trevor Squirrel representing Underhill and Jericho, and sit on the House Appropriations Committee.
Mark McDonald serving the remainder of Orange County, and I serve on Finance Committee and Natural Resources.
Good morning, Ginny Lyons, Senator representing Chittenden County, Chair of Health and Welfare and on Education.
Good morning, Chris Bray. I represent Addison County, Huntington and Buell's Gore. I serve on Senate Natural Resources and Energy and the Finance Committee.
Seth Baumgartz, from the House from Bennington County. I represent the towns of Arlington, Manchester, Sandgate, Sunderland, and I serve on the House Natural Resources, Fish and Wildlife Committee.
Morning, Carol Odie. I represent the far north end of Burlington, and I sit on the House Ways and Means Committee in the House.
Thank you. And Charlene Dindo is our aide that keeps us going, and we march to her drum beat when we do our best work. Thank you, Charlene. First item on the agenda is minutes of November 4th, 2021. Is there a motion? Representative Baumgartz has moved that the minutes be approved. Is there any discussion? If not, all those in favor say aye.
Aye.
All opposed say nay, and the minutes have been approved.
Mr. Chair, could I just note that I was not present during that meeting, so I have not voted.
I would also likewise to say the same.
Thank you both. So noted. First item on the agenda, Department of Financial Regulation Rule, Vermont Securities Regulations. For the department, Aaron Moore, Assistant General Counsel, Department of Financial Regulation, and William Cargan, Deputy Commissioner of Securities, Department of Financial Regulation. Who would like to lead off?
I will be the primary witness for DFR, so I will lead off, and if Bill needs to chime in, he's welcome to at any point.
So identify yourself for the record and start us off, please.
Certainly. Good morning, Mr. Chairman and committee members. My name is Aaron Moore. I am an Assistant General Counsel at the Vermont Department of Financial Regulation. I am joined today by Bill Garrigan, who's Deputy Commissioner of the GDFR's Securities Division. As you mentioned, we're here today to present testimony regarding DFR's proposed amendments to rule number S-2016-01, which is the Vermont Securities Regulation. As way of background, one of the DFR's responsibilities is supervising and regulating organizations that offer investment and financial services and products, including broker-dealers and investment advisors. One of the ways that the DFR carries out this responsibility is through the Vermont Securities Regulation. This rule was originally adopted in 2016, and it was last amended in 2019. I'm here today to address the DFR's proposed amendments to the Securities Regulation. Through these proposed amendments, we are seeking to improve readability and internal consistency, and to ensure that the regulation is drafted in a manner that is consistent with model laws and regulations promulgated by the North American Securities Administrators Association, which is commonly referred to as NASA, not to be confused with the more famous NASA. This one has an extra A. Federal securities laws and regulations, and to the extent possible, with the laws and regulations of neighboring states. In addition to minor organizational changes, we're proposing 4 substantive changes. The first one is adopting the NASA model rule requiring investment advisors to complete continuing education requirements annually. We believe this is important because it will promote heightened regulatory compliance while also helping investment advisors better serve their clients by remaining knowledgeable of current regulatory requirements and best practices. Specifically, this requirement requires 12 credit hours of continuing education annually, 6 of which relate to ethical training and regulatory training, and 6 of which relate to learning about financial services products and the industry in general. The second substantive change is adopting part of the NASA model rule requiring investment advisors to adopt a written code of ethics. We believe that this is important because it promotes and improves consumer protection here in Vermont. The third substantive change is requiring investment advisors to establish written policies and procedures to ensure protection of vulnerable adults from financial exploitation. As with the last changes, we believe this is important because it also improves consumer protection here in Vermont. The fourth substantive change, which you all may be familiar with, the need for this, sets forth the procedures for allocating money from the newly created Vermont Financial Services Education and Victim Restitution Special Fund. It's quite a mouthful, so I'll just refer to that as the fund. The fund that was established in 9 VSA Section 5616 to the victims of securities violations here in Vermont. So we believe that this is necessary to implement the distribution of restitution assistance to eligible victims of securities violations. The commissioner is given authority to adopt procedures and forms for applications for restitution assistance, specifically in the statute in 9 VSA Section 5616, subsection E, subsection 1. And as you may all be aware, 9 VSA 5616 allows the DFR commissioner to direct a party to deposit a sum not to exceed 15% of the total settlement amount into the fund in connection with settling a state regulatory or a state securities law enforcement matter. Also, the statute sets forth the maximum award from the fund for each claimant, which is the lesser of $25,000 or 25% of the amount of unpaid restitution awarded in an order, or if the claimant is a vulnerable person, which is defined as someone, again, defined within the statute as someone being over 60 or someone who otherwise meets the definition of the statutory definition of a vulnerable person, the lesser of $50,000 or 50% of the amount of unpaid restitution. So the restitution assistance is only available from the Fund for Securities Violations occurring on or after July 1st, 2019. That is the effective date of 9 VSA 5616. And the statute requires that the application must be filed within 2 years after the deadline for the payment of restitution established in the final order. So DFR's proposed rule sets forth the requirements for a written application form and the accompanying documents required for a claimant to submit a request for restitution under the fund. It sets forth what information the application needs to contain and what information and documents they need to provide to the DFR for the commissioner to be able to determine whether they qualify for the restitution assistance under the fund. DFR plans to have an application form available on its website by January 1st, 2022, assuming this rule is indeed implemented. And we believe that all of these changes are going to facilitate compliance by regulated industry and improve consumer protections for investors here in Vermont. Mr. Kerrigan and I are happy to answer any questions that the committee members may have. Thank you.
Senator Benning.
Ms. Moore, good morning. This is Joe Benning.
Good morning.
I appreciate the outline of the 4 basic requests here. In fact, I wish I'd have heard it before I read or did my best to read through this packet. I am an attorney, but I am totally unfamiliar with securities and exchange regulations and law. So I have some basic questions. As far as the continuing education curriculum, can you tell me who it is that actually develops and delivers it?
Certainly. I can handle that, or Bill, if you would prefer to. Bill actually is involved in NASA and has been on the committee that has been working to develop this and implement it because it is a NASA model rule. So he may be able to answer this more specifically, but NASA, which is the national entity, is going to have approved committee or approved providers for the continuing education. And there is a provision where essentially broker dealers can get themselves, the entities can get themselves registered so that they can, or authorized so that they can provide their own continuing education. Similar with legal continuing education classes, how a bar association or a law firm can also seek to be able to provide their own continuing education courses to their own attorneys, and they will still get credit for that.
Thanks, Aaron. If you don't mind, I think I could chime in perhaps and shed a little more light on that. I'm not going to burden you with all of you with having to see me. I'm sitting in a dark room, actually, at the Capitol Plaza. So as Aaron mentioned, I actually head up one of the sections for NASA, which is the investment advisor section. And I've been dealing with this continuing education requirement for investment advisors since we started talking about it back in 2014. A number of our investment advisor folks are also registered broker-dealer agents, and therefore their firms are members of FINRA, which is the Financial Industry Regulatory Authority. One of the things that we looked at with this model rule is any broker-dealer agent who completes the requisite regulatory element continuing education for their broker-dealer firm, 6 hours of those continuing education credits will count towards this 12 number. The courses essentially have already, the majority of them have already been developed, and they are being provided to Prometric, who is essentially our account manager for the continuing education program. And they are in the process, as we speak, of approving vendors as well as courses. And there'll be a substantive amount of courses that these folks will be able to take, similar to the insurance continuing education program that's in place at this point. And I am, as I mentioned, a member of the committee. So I work with the folks at FINRA and the folks at NASA. And we are also developing some of our own content within NASA as it relates to ethics. So essentially, that might be a little bit more of a long-winded answer to your question, sir. But I wanted to make sure that it was a wholesome response.
Well, it was very wholesome, and in the category of long-winded, I think you did okay, but let me ask a long-winded follow-up. As I understand it, then, if FINRA accepts the programming curricula, and it will automatically be assumed permitted under Vermont's regulatory authority. Am I safe there?
That would be correct, based on the way the model rule was written. Because I also, I chair the group that works with FINRA to develop the regulatory aspect of continuing education. And essentially the committee I work with, we then essentially put together a document to NASA attesting to the fact that the quality of the education that is being developed by FINRA meets the requirements of NASA and should therefore count as the 6 hours of the products and practices piece of the IARCE model rule. So short answer, yes.
And if a firm developed its own curriculum that was not reviewed by FINRA, how would they approach Vermont's regulatory authorities and ask permission to have this approved?
Excellent question. And quite frankly, we tried to make it easier than that for anybody that wants to develop content. And this is all, there's a lot of information out there on the NASA website about this, but essentially the way it works is anyone who would like to develop content submits it to Prometric, who is also, very heavily involved in the insurance CE piece as well. They submit it to Prometric. Their folks review the curriculum, determine the amount of credit hours that course is worth, and then they approve it, and it's available to anybody to participate in. And then that product sponsor, whether it be a firm or a CE entity, who that's all they do is develop CE, then they can offer it out to anybody across the country. So it's not just a Vermont piece. It's a national program.
Okay. Two more brief questions. I hope the code of ethics that you're talking about, I noted on page 26 of the annotated version of the rule, there begins about 31 or 2, what I would consider to be codes of ethical requirements. Is that a code of ethics has already been developed? Because the way this is being presented is that a code of ethics will be developed. And I'm wondering if, is the cart before the horse, or is it actually something you're expecting to be developed in the future?
Aaron, I don't have the document in front of me. I don't know if you do.
I do. So the code of ethics is that the firms, the investment advisors, firms are supposed to develop their own code of ethics so that they will have a written code in place. Again, in the vein that I'm more familiar with in the legal community, it is not uncommon for law firms to have a code of ethics that they, in addition to the, ones required, imposed on us by the bar associations and the state bars, that just sets forth the standards that they expect of their employees and their investment advisors.
So how would the state of Vermont enforce anyone who is in a firm if they have violated the firm's code of ethics?
I don't believe
So,
that.
I can speak to that. So essentially, we're talking about state registered investment advisor firms here, which the Securities Division has, is the only regulatory body for a state registered investment advisor. They do not fall under any SEC regulation. A part of what we do on an annual basis is send out an annual questionnaire, which is essentially a desk audit. And if that item needs to, if it's a required document, then the firms would also be developing written supervisory procedures in order to incorporate that aspect. And if they have folks within their entity, which quite frankly, our investment advisor folks are not our problem children, for lack of a better word, that would be looked at as potentially a failure to abide by their WSPs or their written supervisory procedures.
It sounds like you're one step removed. If somebody were to become a vulnerable adult who has experienced some fraudulent action that is in violation of the firm's code of ethics, if I understand this correctly, Vermont's regulatory authorities would not have the ability to impose some kind of sanction as a result of that violation. It would be the firm that would be imposing the sanction. Am I missing something?
Yes, that's actually not accurate. The firm obviously has a responsibility to supervise the folks that work for them. The Securities Division has regulatory oversight over these firms, and as it relates to financial exploitation of a vulnerable adult, that is also incorporated currently in our regulation. And there's a mandatory reporting requirement for firms, whether they be investment advisors or broker dealers, to notify the division of any and also make a simultaneous notification to Adult Protective Services so that we can implement an investigation and see exactly what is happening, and we have the ability to halt any disbursements from coming out of that account. So we can stop whatever transaction the individual trying to exploit a senior is attempting to do. We can halt that before the money leaves. So we do have regulatory oversight over both the firm and the individual, because the individual investment advisor representative also has to be registered with the Securities Division. So we do have oversight over both pieces of that, if you will, both the firm and the individual.
Okay, I'm trying not to hog the time here, and I apologize, Mr. Chair. I just want to make sure I'm comfortable in on this rule. If I understand you correctly, then, if an individual files a complaint with the firm about a violation of the firm's ethical code, the firm is responsible to notify you immediately of that complaint. Am I correct?
Well, my answer would be maybe. It depends on what the complaint is. It's if it's related to the potential financial exploitation of a vulnerable adult, no, the firm doesn't have a choice. It's a mandatory reporting. If it's something else, some other complaint, perhaps within, within the code of ethics, it may or may not rise to the level of the firm having to report it to us. But when we go in there to do an examination, we are going to see it, or when we ask about it during the annual questionnaire period with the firms, we would be able to see it, and at that time determine whether it was something that rose to a violation of the Vermont Uniform Securities Act. And we would also be looking to the firm to see how they handled it and try to work with them, to ensure that violations of their code of ethics are few and far between. Obviously, we want to allow people to do what they need to do and don't want to be, kind of a quote unquote gotcha regulator. That's not our point. We want to help them to do the things they need to do. But a lot of that is up to the firm to then take corrective action based on whatever the activity was that may have violated the code of ethics policy.
I just want to be clear, if a firm is the one required to develop its own code of ethics, that code of ethics is not approved, as you will, by the state. If a complaint is filed that automatically triggers review by the state would then have the opportunity to step in. But if a complaint is filed that violates the firm policy, the state would not get notice about that unless it did trigger an automatic review. And if the aggrieved party wanted to appeal a decision by the firm that it had not violated an ethical code sentence written by the firm, not approved by the state, that individual would not have the ability to go to the state, or would they, to appeal that decision?
Well, again, I'm going to go back to, it would depend on what the violation was. But the short answer to your question is, if a client of a firm, whether it be a broker dealer firm or an investment advisor firm, a Vermont resident, if they have issue with something that has taken place or an activity that has taken place by either a broker dealer firm or an investment advisor firm, they always have the ability to file a complaint with the Securities Division, and we can then investigate the complaint.
Okay, my last question. Written policies and procedures that a firm has to develop, are they reviewed by the state?
They would be developed on a regular basis as part of our examination program. Yes.
Okay, thank you.
And just as a high level, the majority of our investment advisor firms utilize third-party compliance consulting firms to help develop things like their written supervisory procedures and their code of ethics. So this is not something that would be a quote unquote heavy lift for these firms. A lot of the compliance consulting firms provide these codes of ethics then to be customized based on the firm's business model. But it just, it kind of goes in to what we're saying as it relates to consumer protection.
Mr. Chair, I'm done with my questioning, except to ask, did we receive any comment from the chairs about this particular rule? Because if we did, I don't recall seeing it.
I think I saw Senator Cummings on the back of one of the memos that Charlene handed out to us. I'm not the chair, but that's 2016-01. What's the number of this? Yeah, so that one is from Senator Cummings. She says it meets legislative intent. On the back,
I'm being shown it. by Legislative Council.
can I ask a follow-up question about all of this?
Senator Lyons.
So I'm intrigued by the discussion on vulnerable adults. And a few years ago, we put in place some protection, financial protection for vulnerable adults, including some, I believe, some mandatory reporting, and I'm looking at my alleged counsel to confirm that. But I have not researched how this set of rules relates to the statute that we have through our Agency of Human Services. And I'm questioning if you folks evaluated the rules based on Vermont statutes relating to vulnerable adults and financial protection.
We referenced in the regulation, the statute with the definition of vulnerable adults. And that is, in fact, in terms of the restitution piece of it all, the restitution fund, that the definition is specifically incorporated that a vulnerable adult who would be entitled to a higher amount of money under the restitution fund is an adult that's age 60 or over, or someone who meets the definition for a vulnerable adult under 33 VSA section 690214.
It's one thing to reference a definition or a set of definitions. It's another to reference the statutes which offer protection from financial abuse. So I haven't looked at that, and I haven't talked with my legislative counsel about it, but I do think it's something that I would be concerned about. If a firm is making a decision through its ethical guidelines not to report, and if that would rise to the level of statutory malfeasance, then I would be very concerned. I haven't heard anything that reassures me that that doesn't happen.
I don't think that there's anything that is telling them that the parts that we are including in this rule are not changing anything other than that the firms are required to establish a written policy and procedure, both related to ethics in first part and the vulnerable, to ensure protection of vulnerable adults from financial exploitation. It's not defining, it's not trying to change the definition of what those things are. It's merely requiring that they have a written policy that we can then review, as Bill was mentioning, as part of our audit, for lack of a better term. When we go and look at what their documents are, it becomes a required document that they need to show us so that we can see what it is that they have created. It's not altering the definition or otherwise impacting what Vermont views as a vulnerable adult.
Okay, thank you. I have another question. May I ask it now? I'm looking at page 75 of the annotated version and number 7, which allows for the discretionary waiver by the commissioner to, better put my glasses on, I won't be able to read it. May commissioner in his or her discretion waive any requirements of this rule. And there's another section on another page, 78, and I don't know if there are others that allow for discretionary waiving of either specific portions of the rule or the entire rule. I'm trying to understand, my first question, does this allow for the commissioner to waive any part of the rule that we have before us? Because it doesn't state that it's just for continuing education, for example.
Sorry, could you give me the specific reference to the section?
Yeah, yes, it's page 75 of the annotated version. and it is number 7 under
Near the bottom.
F, I think. It's near the bottom of the page on page 75. Investment advisor representative continuing ed, but the line reads that the commissioner may, in the commissioner's discretion, waive any requirements of this rule. That seems like a very broad statement, even though it's placed within a specific section of the rule.
It was not intended that the commissioner could waive everything within the entirety of the regulation. But the commissioner it does have broad authority to waive certain requirements. It's not just in this provision that it's specific.
It is in another, at least one other section. So is there a process for that waiver to occur? Or is it simply a letter to the commissioner? How does that happen?
I would envision that it would be some sort of communication with the commissioner directly relates to that subsection. I don't think that it happens very often. I would imagine the place where the discretion, where we're adding language where there's discretion that may come up more often in this instance would be, again, in the restitution fund piece, because there he has it specifically, explicitly, he would be able to waive a requirement for perhaps the obligation that the claimant provide a copy of the obituary of the deceased in the event that their person died intestate. Perhaps there was no obituary for that person. There wasn't one published anywhere, and so he could waive the requirement for that. And I would envision that would be, again, submitted through some form of letter, written communication with the commissioner, certainly.
Okay, I don't have any other questions, but I do have concerns about both the things I was asking about, and then finally a concern regarding the ability for this to change depending on whatever the national group decides to do. That's always a concern with rules like this. Thank you.
Mr. Chair.
Senator Bray.
Good morning, Ms. Moore. I have a question. It's maybe more a sort of higher level constituent question about the rules. There's many cross references in here that I'm unfamiliar with. And one of the things I know I get asked is, do people in this industry have a fundamental fiduciary responsibility to customers? Sometimes people feel as though they've been put into situations that are not necessarily in their best interest, may have high fees, et cetera. And they wonder if this is within the guideline, acceptable within the guidelines of the law or so can I just ask that general question?
Sure. Aaron, if you don't mind, I'll answer that. So an investment advisor is held to a fiduciary duty and a fiduciary standard, which means every recommendation has to be in the client's best interest. And broker-dealer firms have recently adopted what's called regulation best interest, or Reg BI, where broker-dealer firms now have to, at the time of a recommendation, that recommendation has to be in the client's best interest. So it's no longer just a suitability standard. It's been elevated to a fiduciary duty.
Thank you.
You're welcome.
Are any further questions for the witness? I'm going to try one. Rules. We have a practice of accepting national rules. Rules that have been for example, about electrical codes. And we accept them as part of our rules. And when the electrical codes change, we accept the changes. But electricity and codes are pretty much black and white. When you get into ethical situations, what prevents a firm from simply saying, we've reviewed this and it doesn't appear to rise to the level of a violation? How does anyone, how is that adjudicated, or how are people notified when that is the opinion that a firm has, that when they've looked at their own situation, they say it doesn't rise to the level of whatever? Is that a problem here?
So I guess the short answer to that is the securities industry, whether it be at the state or federal level, is very highly regulated. Broker-dealer firms fall under the auspices of FINRA, which is under the SEC. So there are mandatory requirements that have to be made as it relates to handling these sort of duties. And there's a specified conduct that all firms have to exhibit. And we do the same thing at the state level. We have secondary regulation over broker-dealer firms. We also have some oversight over SEC covered federal advisors. And as it relates to state registered advisors, we are their primary regulator. That being said, we have a robust examination program. We also have implemented what's called our annual questionnaire, which is as I mentioned earlier, it's the equivalent of a desk audit. We ask a lot of questions on there, particularly if we see problem tendencies or red flags come up during the course of the year. We will ask specifically about those areas. Firms are very responsive. They very rarely, if ever, at least in my history, I've been in the securities industry since 1993. I've been with the securities division here at the state for almost 15 years. Our firms are held to a very high regard. Most of them hold themselves to a very high regard. We all kind of take this commitment to investor protection very seriously. And there is a lot of oversight. So the likelihood of that happening, one is slim, because most folks that are in this business are choosing to be in it, and they want to be in it for the long term. And a problem that would come to light for something like that would have a considerable detrimental effect to that entity's ability to maintain their registration, and also for that individual to maintain registration in the industry. So they'd be looking at potentially losing their livelihood. Now, that being said, we have also had instances where people didn't do the right thing, and they've been held accountable. And a review of some of our orders and things could show you that. And that's our role, and that's what we do. So I don't know if that makes sense, but.
Well, if I had asked the question about electricity rules, the answer would have been a lot shorter, because the light is on or off. But thank you for tackling that one, and I will ask the committee if they have any further questions. Committee, what's your pleasure? Senator Benning.
I am happy to propose we accept the rule, but I'd like to do so in a way that a red flag is presented. I hope continued conversation. I think that the rule adequately covers one important aspect, and that is the exploitation of a vulnerable adult. That seems to trigger an automatic response by the state, where I'm thinking the rule falls a tad bit short, is in the area where we expect the state to protect consumers against unfair and unconscionable practices. And specifically, the ability of a firm to design its own ethical code that does not have to be approved by the state and would not be reviewed by the state by someone who is not a vulnerable adult unless it was picked up in a subsequent audit of what the firm was actually doing. It leaves me a little uncomfortable. And I think it warrants further conversation. And I'm hoping that that is enough in my little brief speech here to suggest to the parties that be that this ought to be a topic of conversation. But in spite of that, I will move that we approve 21P29.
Senator Bray.
Just a quick question to, so I understand Senator Benning's motion. Are you also recommending, for instance, that the committee write a letter to committees of jurisdiction as well, or something less formal than that?
I was going to be happy to do that at a later point in time, but I didn't know that that was necessarily at this moment in time. But if that is of concern as to whether anybody who would choose to vote for or against this, then I'm happy to include that in my motion. And we do write a letter to the committees of jurisdiction and just ask a simple question. Why isn't the firm developed ethical rules, and I'll add to that, their policies and procedures, not subject to some kind of guideline that the state puts out? I think that sort of covers it.
Yeah, thank you. That is helpful.
Is there any further discussion? Senator Benning, there's an expression about a lawyer that represents himself, and how does that end?
They have a fool for a client.
And a company dealing with making ethical decisions about its own practices, how do you end that one?
I would think they have an ethical off-ramp.
Which I think sums up the uneasiness we all have with the motion before us, which is what we have before us. So we're fair.
I do think, Mr. Chair, that it is important to get a rule out to protect vulnerable adults. I think we can all agree on that.
Yep.
And I don't have any quarrel with the way that this rule does that. Where I find it falling short is on the consumer protection in general. Is there some kind of obligation on behalf of the state in expectation of what legislative intent is to make sure whatever ethical rules, policies, or procedures are developed by a firm meet a certain set of criteria? I don't even know if that criteria has been developed, but it is certainly a subject of conversation for our committees of jurisdiction.
And has been the subject of this committee's for the last 15 or 20 minutes. Senator Benning has moved that the rule be approved and has suggested that later in the meeting, we send a letter to the committees of jurisdiction on the matters that we get. And speaking of, are we ready for the question? So, all those in favor say aye. All opposed say nay. And the rule has passed. Thank you. Second item on the agenda, which the second, third, and the fourth all are sort of a package. And Thea, do you want to? And there's a question about this has been presented to us in a somewhat different way than we usually get. You have any warnings for us or advice?
Not warnings, so much as just highlighting the fact that these three rules were filed as emergency rules. And under statute, emergency rules are appropriate in an instance that doesn't apply here, but in the one that the agency is pointing to is where an agency believes that there exists an imminent peril to public health, safety, or welfare, it may adopt an emergency rule. And then in addition to the grounds that LCAR can object to permanent rules, one of the grounds on which you can object to an already adopted emergency rule, because remember, emergency rules are adopted as soon as they're filed, it's not a post LCAR thing. One of the grounds on which you may, and it's discretionary, object is if on a majority vote of the entire committee, the committee may object for this subsection if an emergency rule is not necessitated by an imminent peril to public health, safety, or welfare sufficient to justify adoption of an emergency rule. So if the committee were to determine and have a majority vote of the entire committee that it didn't meet that standard, the committee could object to the rule, and then that sort of places the flag on it for purposes of shifting a burden of proof if there was a legal challenge. One of the things to highlight is in statute, it says a majority vote of the entire committee, the committee may object, so discretionary. And in subdivision E2, it says that the failure of the committee to object to a rule is not an implied legislative authorization of its substantive or procedural lawfulness. So we could determine that it did not meet the standard for an emergency rule, that there wasn't this imminent peril to public health, safety, and welfare, but then decide not to object. One of the things to remember with emergency rules is unless a different date is indicated, and it wasn't here, emergency rules last for 180 days. So you will be, it sounds like based on correspondence you've gotten from DCF, hearing from them either as part of permanent rulemaking. They sent that memorandum yesterday saying that they were going to initiate permanent rulemaking, or you're going to be hearing from them again as for an emergency rule, being as how you're now 30 days into that 180-day adoption length. And this committee is very, very versed in seeing the same rules in emergency form multiple times as you have continued to extend re-up rules due to COVID, and that's why you see a rule, I think, for the impermanent form after you saw it 4 times in emergency rule form leading up to today. So that's a little bit of the background as to the emergency rule.
Thank you for the background. I asked you to brief us on that because there has been a part of the discussion that these rules are come closer to the edge than our usual emergency rules, and I don't have an opinion on that. I'm not trying to prejudice the committee on its what we're going to hear. And at this time, would ask Heidi Moreau, policy analyst for the Department of Children and Families, to share with us the first emergency rule 21E17. And my intention is to do all 3 of them, and then at that time ask the committee to take them one at a time, or something else that the committee might choose to do at that time. So Heidi Moreau, the floor is yours.
Good morning. I'm Heidi Moreau, Policy Advisor for the Department for Children and Families. I'm joined by Nicole Dubuque and Crystal Michaud from DCF's Child Development Division. They're available to answer any program-specific questions that may arise. So the 3 sets of emergency rules that are before the committee today, DCF's Child Development Division was prompted by the U.S. Supreme Court's decision in Fulton versus the City of Philadelphia to file these. And as was noted earlier by Anthea, the department is also in the process of adopting these emergency rules as permanent rules through the regular rulemaking process. So without getting too in the weeds of the Fulton decision, the court there held that when a policy, requirement, or rule is not generally applicable, those requirements can't be enforced without a compelling interest to do so. So the specific facts in that case were the city's standard foster care contract permitted discretionary exemptions to the contract's non-discrimination requirement. And it was found that the city couldn't refuse to contract with a religious foster care contractor who was seeking an exemption to that non-discrimination requirement. So in the 3 sets of CDD rules before you today, all 3 sets of those rules have variance provisions that allow CDD to grant variances to any of the rules as long as the intent of the rules can be maintained. So to ensure that CDD can continue to enforce the non-discrimination provisions within those rules and to ensure that childcare is being operated and offered in a non-discriminatory manner to all families, the emergency rules circumscribe the discretionary authority to grant variances to the non-discriminatory provisions of the rules. So in 21E17, Rule 2.7, the rule variance rule was amended to prohibit variances of Rules 3.5, which is non-discriminatory enrollment, Rule 4.7, communicating family child care home policies and procedures, 6.1.4.3, respect for diversity, and 6.2.3, quality of interactions. And would you like me to summarize the other two sets of rules, or do we want to take them one at a time?
Briefly.
Okay, so in the next set of rules governing after-school childcare programs, again, the variance rules were amended to exempt new language new non-discriminatory language that was added that mirrors both the family childcare home and the center-based childcare and preschool program licensing regulations. And then in 21E19, the center-based childcare and preschool program rules, similar amendments there. The rule variance rule was amended to prohibit variances of all the non-discriminatory provisions of those rules. And I'm happy to answer any questions.
Questions for the witness? Senator Benning.
Ms. Moreau, good morning. Our chairs have raised the question, and when I say the chairs, I'm talking about the committees of jurisdiction, about whether this has been generated, or rather necessitated, by an imminent peril to public health, safety, and welfare. Do you have a response to that?
So the department believes that the provision of non-discriminatory childcare consistently throughout the whole state, the inability to do that would represent an imminent threat to public welfare.
Can you elaborate in what way?
Well, I guess I could speak in terms of hypotheticals. If a child care provider were cited for a violation of the non-discriminatory provisions, and then they were to appeal that, they could possibly rely on the Fulton decision to successfully be exempted from the non-discriminatory provisions, which means that they could refuse to enroll certain children based on protected statuses under Vermont law.
Okay, thank you.
Senator Lyons.
I'd like to ask Ledge Counsel McClin just to comment a little bit about the Fulton decision and its relevance as promulgating an emergency rule. If you wouldn't mind doing that, and how you think it may not be related or is related.
Thank you. Katie McGlynn, Office of Legislative Counsel. So I guess I just want to caution the committee. I'm happy to kind of give you an overview of what Fulton says, but just really focus your attention that the issue before LCAR is the emergency issue and not so much how Fulton is being interpreted. So as Ms. Moreau very nicely laid out, the Fulton decision was a decision that came down from the US Supreme Court this June. And in that case, the city of Philadelphia contracts with a variety of foster agencies. And those contracts that are issued have non-discrimination language in each contract. And those contracts also have a variance provision. And the variance provision in those contracts says that a variance may be granted at the sole discretion of the commissioner. And so one of the agencies that the city of Philadelphia contracts with is a religious-backed organization. And the reason this case arose in the first place is because it came to the city of Philadelphia's attention that this particular agency was not placing foster children with same-sex families because they felt it violated their religious beliefs. And so the city of Philadelphia argued, in turn, you're violating this anti-discrimination clause in the contract. And that is how this case first came to be. It went through the Third Circuit and up to the Supreme Court. The Supreme Court took a look at this issue, and what they ended up doing is, I think everyone was expecting a decision on religious grounds and maybe really changing the jurisprudence in that area, but the court's decision was very narrow. And what they focused on is this variance language in the contract. And they said that because there is this variance language and it's generally applicable and at the sole discretion of the commissioner, that's where we feel like there is a free exercise violation. So that's sort of what's happening in the case itself. I think there are potential arguments that the court was very focused on the sole discretionary language of that variance, whereas the variances and the rules before you have some parameters for when a variance can be issued. There's a distinction there. I don't think the Supreme Court really drills down on if that makes a difference or not, but that's certainly a potential argument. And then, something else that I do think is worth noting is that the rules are not similarly situated. You have 3 rules in front of you. They all have the variance language, but only E17 and E19 have discrimination language. So E18 does not have the discrimination language. DCF is adding that in today. So they're almost creating the circumstance which requires, or at least which they would argue requires, a response under Fulton. So there is a distinction in the 3 rules.
Can I ask one more question?
Senator Lyons.
Yeah, so as you started out your discussion, you indicated that the question before us isn't necessarily how this relates to Fulton as much as it is about whether or not these rules meet the criteria that we have in APA for emergency rules. Can you, I know that you and Anthea worked together on a memo. Can you just talk about that a little bit?
We didn't put together a memo, but we did look at the standard that Anthea reviewed with you. Did this rise to the level of, do you have the exact language, an imminent peril to the health, safety, and welfare?
Imminent peril to public health, safety, or welfare. There's that.
And so initially, when we were reviewing the rule, that was a concern for us, whether that statutory standard was met, and that is a decision for you, not for us. But I think one part of the concern was that the decision came out in June, and there had been a significant lapse in time before we were seeing this emergency rule. And I think that made us curious how great an emergency it was. And then as we looked into the Fulton case and, that the potential issue had to do with this variance language, I think we continued to be concerned and wanted more information about why the department felt that it rose to the level of an emergency rule.
Thank you.
Does the witness have an opinion?
I think that's a decision for the members of this committee.
Senator Bennett.
Can I ask that in a more subtle way? Concerns still exist.
my concerns still do exist, based in part on some work that Anthea did looking at definitions of the terms around an imminent peril. What does imminent mean? What does the health and safety mean? And in the absence of having great case law that's looking at what is the standard for emergency rule and interpreting that, we looked at the plain meaning of the words, which is a tool that courts often use when they're trying to reach a decision. And in large part based upon, the plain meaning of the words, I wasn't confident that the rules that DCF was putting forward as emergency rules met that standard.
So, Mr. Chair, if I might, Kate, you're speaking, but I would like to turn to our own ledge counsel. Despite the fact that she has the greatest poker face, even with a mask, do you still share those concerns?
I'm going to echo what my colleague said. I think that you are in a position where you get to make that decision. I will take this opportunity to tell you what the dictionary defines imminent and peril as. So imminent is likely to occur at any moment, impending, and peril is injury, loss, or destruction. So I would go to that framework if you are getting to a point where you're determining whether or not there is an imminent peril.
Senator Bray.
I'd like to ask a question about our council on procedure. I noticed that it says for engaging the public in the development of a proposed rule, it's not applicable. So I could understand that in a quote unquote emergency. But is that a general provision of APA and emergency rules that no public engagement is required?
So the main distinction between the permanent rule track and the emergency rule track is for permanent rulemaking. That's where you've got it's proposed, it's filed in proposed form of ICAR. ICAR takes it up. That's why you see ICAR minutes. It's then filed with the Secretary of State. There's usually a hearing. There's the opportunity for public comment. And it's after all of these steps happen that the rule comes before LCAR. And when it comes before LCAR at that point, it hasn't been adopted yet. But with emergency rulemaking, as soon as it's filed with the Secretary of State's office, it is adopted as an emergency rule. So these rules that you see in front of you, even though you've got your annotated version and your clean version, that is the rule at present. It has already been adopted. It was adopted when it was filed, and in 180 days, less about 30 days, that rule will go away and will go back to the version that existed prior to the adoption. So not only is it normal for there not to be the opportunity for public comment in emergency rulemaking, that is one of the key differences between going through the permanent rulemaking process and the emergency rulemaking process under statute.
Thank you.
Further questions? Questions to the witness? Questions for our counsel?
Right next to your chair. Yeah, I guess I'm asking this question of Ms. Moreau. And I want to echo what Pledge Counsel Katie McGlynn said, that the Supreme Court case was decided in June and we're seeing this in November. That's a concern, that lapse in time. First question, has the permanent rulemaking started?
The permanent rulemaking, all of the documents are have been drafted, but it hasn't been filed. It hasn't been pre-filed with ICAR yet. It hasn't been routed for the Secretary of AHS's signature yet.
Yeah, it seems to me that if you had started the permanent rulemaking at the point where you interpreted Fulton in the way that you have, that you'd be close to finalizing permanent rulemaking given the time frame. My other comment is Senator Benning pressed you on the issue of imminent peril to the public health, safety, and welfare, and asked for you to sort of defend that. I guess I would have to say that I found your answer less than compelling. And as our Pledge Council has indicated, because it's emergency rules, there are in place. I think the chairs of the committees that would have oversight over this issue in terms of the content of the rule, believe it meets statutory intent. But we have a job to do as a committee. And it would be very easy, I think, in some respects for us to say, well, no big deal, right? You guys just didn't get it right next time. But I think we have an obligation as a committee to follow the rules and follow the APA. And at least in my opinion, you did not do that. And I'm not offering a motion at this point, but wanted to share my concerns and my opinion. Thank you.
Can I ask,
Chair White.
yeah, our Pledge Council, so we're in a conundrum, obviously, because I think at least some of us believe that this is not an emergency rule. And yet the substance of the rule is applicable and seems to follow statutory requirements. What kind of a motion can we make? I mean, if we move to accept the rule, are we also accepting the supposition that it is an emergency rule? How do we proceed?
So the APA does specifically address that. So in addition to laying out what happens if LCAR were to object, which is that burden of proof shifting if there is a legal challenge, it provides, and this is both an emergency rulemaking objection language and a permanent rulemaking objection language, that the failure of the committee, and that's this committee, to object to a rule is not an implied legislative authorization of its substantive or procedural lawfulness. So you could choose not to object, and that failure to object is not deemed to be an implied authorization of the process that was followed in getting to the point of this rule being adopted in emergency form, which is already happened. So it's different with the objection being after the fact as opposed to before adoption. That language is included in both permanent rulemaking and emergency rulemaking statute.
Senator Benning.
Mr. Chair, are we just discussing this as a committee now, because that's where my comments?
We do not have, we're looking at 3 rules. We don't have a motion on any of them.
Then I'll make a motion. With respect to 21 E17, 21 E18, 21 E19. Move that the committee object on the basis that we don't believe it falls within the criteria of an emergency rule. And just by way of explanation, I am less concerned about the burden of proof shifting to the department during a time period when we are about to have a legislature reconvene, properly address this subject, or the department itself developing the permanent process. I'm less concerned about those things than I am about, even given Anthea's explanation, the impression that we leave to anyone that we are willing to bypass what really should be the proper triggering device for determining whether the rule meets the emergency criteria.
That you're not making a motion to not object to the rule. You are making a motion to reject the rule.
We have the power to reject a rule. We have to, I believe we either have to approve it or object to it. I don't think we have the power to just say goodbye.
I'm gonna,
Excuse me, parliamentarian, we could also pass over and not address this.
Right, so with emergency rulemaking, remember this has already been adopted, and if you are going to draw a parallel to permanent rulemaking, LCAR doesn't need to act to approve. Your failure to do anything is usually I mean, you, in practice, for all the rules, you're usually approving them or approving them with a change. It's LCAR's power is one of objecting. So you can either not act, which continues to let it be an emergency rule without objection, or as Senator Benning has moved, which is to object, which would then place that sort of notation on the rules and the burden of proof shifting, which Senator Benning said was not his primary focus, but from a legal perspective, that's what the objection is.
I've served on LCAR for quite some time, and emergency rules grant the administration, any administration, wide latitude, the ability to make summary decisions, to step in when time is of the essence. And the concerns that seem to be expressed here today is that there's been a long time between the decision in Philadelphia and today. Senator Benning's motion would send a pretty strong message to the administration. I think maybe there's been once in the years I've served on here where we've objected to emergency rules. I'm concerned, for the reasons that Senator Benning and Sarah Lyons and the witnesses set forth and our counsel. So I think we could send a message by passing over it and send them a letter saying what we might want to say, or we could act on Senator Benning's motion, and it's up to the committee to decide what they think would be most useful, and send a message that I think there's merit in granting administrations opportunities and emergencies to step in and do what they have to do, and using their discretion wisely. And maybe this is a time when you can question the timing on it. Senator Lyons.
I think that in the interest of allowing for the child care homes, after school program, and family centered homes, some reassurance that the rules have met the substantive requirements of statute. I would not like to vote against. I would not like to object, but I do think we should pass over, and I do think we should ask for permanent rulemaking with alacrity.
Which has already been started?
Theoretically is happening.
Is in process? Is the permanent rulemaking already in process?
It hasn't been pre-filed with ICAR yet, but all the documents are prepared and are just need to be routed for signature.
So the first step has been taken in permanent rulemaking?
Sorry, could you repeat that?
They have the materials together. File.
Senator Benning.
It pains me to say that I listened to the wisdom of my colleagues. But can I ask legislative counsel a question?
Certainly.
With respect to passing over, has that had any impact on the burden of proof?
It does not.
With that, Mr. Chair, I will withdraw said motion. One second. I will instead advise to say with respect to 21E17, 21E18, and 21E19 that we pass over those.
I'm going to ask counsel again, were we to do that? Could we take them up at a future date if we wished?
I would need to touch base with the parliamentarian side of things. In that
The question is, if we pass over, if we set ourselves down a trail we can't
So what you're doing is you're not objecting to them,
Yep.
which is really all you can do.
Senator Bennett, is that your motion to
Well, that's
withdrawing
my
substitute?
motion, I understand.
Yeah.
I want to make very clear, though, that we have an obligation doing any emergency rule to make sure it meets the concerns that have been expressed by legislative council, both our legislative council and one of the committees of jurisdictions legislative council. And if we don't make that necessary, I find that very concerning, because there is a double-edged sword. There may very well be a reason in the future for an emergency rule to be brought to us and for us to sort of have pressure put on us to just simply say, okay, we understand, go ahead and provide. But that is a tremendous precedent you are sending to anyone who's going to be asking for the same thing in a situation where we may not wish to have that.
Senator Bray.
I have a question for our council, and that is, so if we were to pass over, is this somewhat akin to tabling something? It stays available to us to act on in any future meeting, as opposed to we've disposed of it in some more permanent way.
So I'm gonna go back to some of the discussions we had a few weeks ago when you had your emergency hearing with LCAR really having the ability to take things up, sort of if the committee chooses to take things up. And there is language in the APA, which was one of the instances that you sort of called that special hearing on, which has to do with, I want to get the language right. The Legislative Committee on Administrative Rules will hold public hearings on a proposed or previously adopted rule on its own initiative. And this rule, by being an emergency rule, was adopted as soon as it was filed. So without regard to action that is taken here, you could at some point in the future choose to have a public hearing on it and take action at that point. I think Senator Benning has expressed a desire to, instead of saying we are not doing anything, we're not objecting anything, to say we are passing over, and perhaps you would want to put in writing either to the Department for Children and Families as to why you're taking that action, or the subject matter committees to express why in response to the concerns that they expressed in the forms that they returned, but not meeting the imminent peril standard. The committee made the affirmative choice not to do something, which is the way I think Senator Beck phrased his motion.
Well, that's helpful. I mean, I think my sense for myself, I'm not really interested in passing over being treated or interpreted as tacit approval. And I think, but it could be sort of de facto tacit approval. So I'd just like, if we're passing over, we can take up at a future meeting, that could, maybe we will develop with further research or discussion, another option to return to this in a future meeting. I just wanted to make sure it wasn't going to somehow be off the table for discussion.
And for that specific concern, I would say that other portions of the APA, the second language that I just read from section 817C, would allow you to take it up in the future, sort of without regards to what happens today.
Thank you.
Mr. Chair, can I ask about council, what would be the impact of us postponing action? I understand on the one hand, we have the ability to call it up since it was a proposed rule.
Well, this is an adopted rule.
Adopted, but even with the case of adopted, do we not have the power to call up an adopted rule if we have some issue with it?
You do, and that's the language from 817C.
So in passing over, is that the equivalent of postponing action or something, or do we have to postpone action with a date in mind to return to the conversation?
So unlike in permanent rulemaking, where LCAR has a 45-day review period, and if you don't do something within the 45-day period, then the agency can go and adopt the rule. This is different procedurally because it's an emergency rule. It is already adopted, and they are ticking down that 180-day clock to when LCAR, or they will need to do something, either get a permanent rule in place, go back to the rule as it existed prior to the emergency rule adoption, or come back and say we'd like another, or to adopt for another 180 days. So I think no matter what LCAR does today, there are many ways to take this up again. If LCAR, the only real thing that LCAR can do that has a legal significance is object. So in your first motion, we're moving to object. That was gonna down one path of we're putting a mark on the rule, shifting the burden of proof. And the other path, it's sort of everything else, not objecting. You could not object and send a letter. You could not object and affirmatively pass over. You could not object and say you want to take it up in 30 days and see if they started the process of permanent rulemaking at that point. You could send them a letter and ask them to come back and give an update on the process for permanent rulemaking. I think you have a whole host of options, and then you have the legally significant majority of committee must approve the objection.
As the motion is currently passed, you're saying that the department has to come back in 180 days.
So as the motion is currently postured, given the fact that this is an emergency rule, if DCF doesn't do anything at the expiration of the 180 days, which based on when they filed is April 16th, 2022, that's when the rule will no longer be in effect. They need to do something if they want this iteration of the rule to continue. They either need to adopt another set of emergency rules, which again, that's them adopting it. It doesn't take LCAR approval to adopt, or it sounds like they've put the paperwork together for rulemaking. Maybe they'll be at a point where they are close to getting the adoption by April 16th, and they're doing what the Secretary of State's office did, where they had the emergency rule for the rule on rulemaking to cover the stopgap when the permanent rulemaking was being approved, because you didn't have quorum that time. But if in one way or another, by April 16th, 2022, DCF will either need to let the rule go back to the iteration it had Fulton, or we'll need to do permanent rulemaking to keep what is in place, or another round of emergency rulemaking.
Thank you. So, Mr. Chair, with that, the expectation that by April 16th, all of our respective district lines will be drawn out in a different way, we'll know what they are. I'm going to stand on the motion that is postured as simply pass over.
Senator Benning has moved that we pass over the 3 emergency rules. Is that correct, Senator Benning?
Yes.
Representative Higley.
Mr. Chair, trying to get my head around all the options here and so on. I approve of the Passover, but I also believe that maybe a letter to both DCF and the Committee of Jurisdiction would be a respectful procedure in advance of that 180 days. So again, I know the motion is out there. I don't know if I can further amend that, or if that's something the committee would agree with me on, but that's what I think could be appropriate for respect for DCF and the committee.
Our practices to act and when we're finished acting, we accept motions to send letters for that purpose. That's usually the way we do it.
Thank you.
Thank you.
But there is a quicker way, Mr. Chair, and that is the movement, I believe, could simply accept that as a friendly amendment. And I want to use that opportunity to say to the department, I'm not objecting to the substance of the motion. What I'm trying to make sure is we don't, as a committee, set ourselves up for a future problem in which this might actually come back to us and haunt us in a big way.
So, and then along those lines, then I think that the letter should be very firm in our commitment to our interpretation of what an emergency rule is based on the APA. And I know Anthea is good at that.
That's just a signal to Anthea that she should pass that letter in front of Senator Lyons before it goes out the door.
Such letters are routinely with the chair and vice chair and when chair and vice chair feels appropriate to bring it back to the committee for approval before they left. Which I think we would fully intend to do. So Senator Benning has made a motion. Is there any further discussion? The motion includes the notion of a letter to be with the committee's jurisdiction. Are we vote? If so, all those in favor say aye.
Aye.
All opposed say nay. And the motion has passed. And our council will draft a letter on our behalf to this. And no, this is just, okay, we've had the discussion and it's done, which brings us to number. This is where I usually get something wrong. Okay. 21, P20, Department of Health, Portable and Communicable Diseases Emergency Rule. And David Englander is our witness. David, Mr. Englander, are you here? Or someone here? Yeah.
Actually, good morning. It's Brendan Atwood from the Department of Health. I'm having some technical issues that I've not encountered before where the audio is working, but I'm getting a message my video is not. I presume you can't see me? Oh,
Yeah.
There we go.
Begin again. Your communication for some of us is, I don't want to say, it's not you that's garbled, it's the machinery that's sending it to us. So speak a little more slowly, please, and the floor is yours.
Sure. Thank you very much. I just want to stop first. Can you hear me okay now?
We'll manage. Thank you. Go ahead.
Great. Well, thank you again. Good morning, Mr. Chair and committee members. My name is Brendan Atwood. I'm a policy advisor with the Department of Health. With this filing, the department is proposing to renew the Reportable and Communicable Diseases E-Rule. The Reportable and Communicable Disease Rule requires that diseases that are dangerous to public health be reported to the department. And there are several changes being proposed in this rulemaking. First, this rulemaking adds COVID-19 to the list of reportable diseases. Additionally, this rulemaking clarifies how diseases are to be reported to the department and by whom. And then finally, this rule requires that certain demographic data be reported to the department, including race and ethnicity. In drafting this rule, the department worked with Vital, who is supportive of these changes. And I will also note that the department did recently start the formal rulemaking process to amend this rule, so you are likely to see this again before you in the coming weeks. So with that, I'll be happy to answer any questions that you may have.
Questions, Senator Representative Bungard? Questions for witness? No questions?
Mr. Chair, I'll make a motion.
We're
Mr.
shocked.
Atwood off the hook earlier than he probably expected. Move that we approve Rule 21-E20.
Senator Benning has moved that the rule be approved. If there are no further questions, all those in favor say aye.
Aye.
Opposed, say nay. Goodness, it's the opposite of hitting bankruptcy on Wheel of Fortune. Thank you.
Very much. And I believe I've got the next one as well, if I may.
Okay, last one.
Great. So again, I'm a policy advisor with the Department of Health. And with this filing, the department is proposing to amend the hospital licensing rule. I'll note up front here that the committee.
My failure. We're taking up 21 P27 Department of Health and Hospital licensing rule. And Mr. Atwood is doubling down on his good fortune. You may continue.
Thank you very much, Mr. Chair. So we are proposing to amend the hospital licensing rule. And I will start by noting that the committee did recently review and approve this same rule text as an emergency rule. So this should be familiar to you all. But just as a quick overview, the hospital licensing rule establishes the standards for licensing of hospitals here in Vermont. And there are two changes being proposed through this rulemaking. First, this rule will allow hospitals that have been granted waivers by the Centers for Medicare and Medicaid Services during an emergency to be automatically granted waivers for their Vermont licenses. And then additionally, two requirements for psychiatric hospitals have been added to this rule at the request of DVA in order to ensure compliance with the waiver agreement that Vermont has made with CMS. And in drafting this rule, the department worked with the Vermont Association of Hospitals and Health Systems, the UVM Medical Center, DVA, and the Board of Medical Practice, who have all reviewed and support these changes as proposed. And then I will just note again that these provisions are already in effect of the emergency rule. So this really maintains rather than revises the current regulations. And so with that, I'll be happy to answer any questions that you may have.
Senator Benning.
Mr. Atwood, good morning. I hope you can hear me okay. I did have a question about this one. In the intent here, the intent is to do something during an emergency. But the word emergency is not defined other than to say it's referring to a federal regulation. It does not appear that definition inside this rules. I didn't see it anyway. So the first question is, what is an emergency? And more importantly, who declares it, which triggers the application of this rule?
Oh, that's an excellent question, Senator. Thank you. So the federal government, the Health and Human Services, is the one who declares the state of emergency. And all we're doing is essentially reciprocating a waiver that CMS has granted so that they don't have to go through the kind of repetitive steps of, and that would delay their work a bit to request the same waiver from Vermont. So we will not be the ones making that determination. It's the federal government who does so. And our waiver is only contingent on that being granted by CMS during that declared emergency.
So if the governor of Vermont declares a state of emergency as a result of COVID and CMS does not, this rule would not kick in, is that what you're saying?
Just this provision specifically, because this pertains to complying with CMS rules. And so what we're essentially saying is that you've been granted a waiver from CMS to not have to comply with certain rules, we would reciprocate that as well.
Thank you.
Further questions for the witness? If not, what's the committee's pleasure?
Make a motion.
Senator Lyons.
I'll move that we approve 21P27, the hospital licensing rule from the Department of Health.
Senator Lyons has moved approval of the rule before us. Is there any discussion? If not, all those in favor say aye.
Aye.
All opposed say nay. And the rule has been approved. Thank you very much.
Thank you very much.
Which brings us to closing time. The committee. Some of the items that we've taken up in the last two meetings have been more subtle and been more mysterious
Mysterium tremendous.
than we usually do. These are difficult times for committees like ours and the legislature and for the administration. And I'm always proud of this committee that tries to work through the interference that we have in this in the last year and a half to try and make decisions that are keep us moving forward, being productive, and call upon those we work with to reassess how they approach things when reassessment might be helpful. So I thank you all. we will continue to do the best we can here. Senator Bray.
I hate to go through an entire meeting motionless, so I would move, if there's no further business, that we adjourn.
Thank you. Did we say we're going to write a letter on it?
That was what I was gonna ask next. Do
Okay.
you want to take up sort of the second half of Senator Benning's motion on the 21-29 letter?
Senator Benning recommended we write a letter to the committees of jurisdiction on previous rule. And it will, pardon?
Oh, so I have that, and maybe I missed it, that you accepted Representative Higley's amendment. So you have now, for the 3 child care emergency rules, you pass over and send a firm commitment letter to DCF and the committees of jurisdiction. What I was circling back to was 21-29, which is the very dense affirmative rule, as to the sort of conundrum issues that were again about how there could be about the code of ethics that's not linked to state guidelines, and that would be a letter to the committees of jurisdiction.
Hearing no objection, we have, believe we've already given approval to that, and you will prepare that letter also.
And then you can take your vote at the next meeting.
So, seeing no objection, Senator Bray has moved that we adjourn. Are you ready for the question? If so, all in favor, say aye.
Aye.